Thank you, Mr. Chairman. The administration has expressed a preference for trying detainees in Article 3 courts. Do you share the same preference?
Sir, I don't share a preference. I believe that whatever we come up with in terms of modifications to the current Military Commissions Act, as I said in my opening statement, we have to make sure and we have to leave here at the end of the day believing that this is a fair and just system that can stand on its own, and that we ought to be willing to subject any detainee, any terrorist, to the military commission process. Now, I understand that the administration may have, and we may have, some reasons for looking towards Article 3 courts that may cause us in a particular case to defer to an Article 3 prosecution. But I think at the end of the day, we need to build a system that can stand on its own.
I agree, Congressman. In my view, the military commissions process is historically tested. It can be a very fair process. The military commissions that evolved through the Military Commissions Act of 2006 is such a fair process. It currently is being reviewed to make it even more so, to make for transparency, to assure the rights of an accused, to assure that it meets easily international standards. So my preference would be get the military commissions right, do the prosecutions under the military commissions process. Of course, I have no problem if a policy call is made in a given case to prosecute someone in an Article 3 court. That does come down to a policy call. But the important factor is for people to understand that military commissions are fair, they meet international standards, and they are not in any way something just to fall back on because we want to assure a certain result. The military commissions process is fair, and the only guarantee is we're going to provide a fair process. The history through World War II was the almost 2,500 people who were prosecuted in the European and Pacific theaters during and immediately after World War II had a conviction rate of 85%. The cases we've already had, we've seen that people are not necessarily being convicted of all charged offenses, and the punishment that the members decide is appropriate has not been as severe as some people thought would happen. So the military commissions process is very fair, and it should be given a chance to work out. I do support the efforts of the administration and Congress to make it even more fair than it has been.
Sir, I agree with the comments of my colleagues. I'd only add that the process here has to be perceived as fair and just, and there should not be a preference for any one system over the other. Article 3 courts are just another tool in the kit bag that's available to our country for resolving these issues and these crimes.
I believe we are fortunate to have two forums in which we can charge these offenses, both of which meet the international mandates, meet the law of war, and meet those fundamental principles of justice. It's a policy call which forum is chosen. I think we can make both work to achieve our nation's goals.
I'm not trying to get you to talk against the administration. That would be, I understand the situation. My concern is that if you decide to send some to Article 3 courts and some to military courts, is there a judgment made prematurely that indicates that one is less guilty than another, or goes to one court over another? How do you determine which court would handle it? That's one of the concerns I have on that. Are you concerned that this process will buttress the view that military commissions are a second-class system? I think you probably addressed that, and I don't want to put you in a bad light with the administration, but we don't want to come up with a system where one is considered a kangaroo court and one is of a higher, better nature, more fair. That's I think the thing that we're grappling with.
Congressman, I agree. An Article 3 court clearly gives the full panoply of constitutional and other rights to individual accused. The military commissions are designed for a specific purpose. A part of it is based on the very function of a military commission, which is based not on United States constitutional standards for civilian criminal defendants, but the battlefield. Soldiers on the battlefield are not law enforcement specialists. They're not acquiring evidence in strict conformance with constitutional standards and judicial rulings that provide protections. So the point is the military commissions need to be clearly fair and well within international standards. I'm satisfied that they are, and that the additional protections that will be provided will make them even more so. They should not be viewed as second-class justice. On the other hand, as we've said and you've said, it comes down to a policy call. Should the administration decide in a given case to use Article III courts, that's totally appropriate, but they would need to explain why that's the preferred venue in a given case.
Congressman, in the President's National Archives speech, he used the phrase "whenever feasible" in talking about the distinction between going to an Article III court and a military tribunal, a military commission. And we know that the administration is working through a set of criteria, evaluation criteria, to do that, to try to determine. So I think to answer your question, the proof will be, when we understand the criteria that will be applied to make that determination, and then take a look at what cases are being referred to Article III and what cases are being referred to military commissions.